Good afternoon, everyone, and welcome to this month's webinar, which is about protecting your business. First of all, let's do some introductions. Some of you will be familiar with us by now. So our main presenter today is Victoria Templeton, our HR Knowledge Manager, and I'll be supporting her with any questions that you may have. And we are also supported by our team Arden, who will be fielding any technical challenges you have. Our agenda today is to look from the employment relationship, types of claim you can get, redundancy dismissals, managing furlough, and then returning to a COVID secure workplace. Just a reminder on how to ask questions. So we have muted you all today because there's so many of you on here. It would be quite challenging if we left the mics on open. So we do want to hear your questions though. You can do this by using your panel, and you can ask the questions on the question section and you can direct it to the staff. We will monitor them as we go through the webinar, and then at the end of each section we will look for what questions we have and we will field them to Victoria and try and answer them for you. If we don't get to all of your questions, we will answer any remaining ones directly to you after the webinar. We're also going to run a few polls through the webinar, and when this slide appears, you'll know we're going to be asking you a question and enable you to participate. Just to remind if you want to participate in the polls, you need to make sure that your screen is not in full screen mode. As for some reason known only to GoToWebinar, it doesn't work in full screen mode. So if you would like to participate, ensure that you're not in full screen mode. Okay, now that I've finished with the housekeeping, I'll hand over to Victoria, who's going to progress with the webinar. Thank you.
Thank you, Sue. Let's just show my screen. Thank you, Sue. Okay. Thank you, everybody, and thank you for waiting just there while I was just getting set up with the screen. So, and thank you, Sue. So, today's webinar is about how to protect your business. And at a time of uncertainty, and as we continue to respond to COVID-19, managing the employment relationship is even more critical to ensure your business can survive and thrive. The biggest cost to any employer is people, and people are essential to a business's success. However, careful and sensitive management of ending as well as maintaining the employment relationship whilst balancing the needs of the business will be key. So today's webinar, we're going to look at the employment relationship and see what types of claim employees can pursue. We're going to focus on redundancy dismissals and how as businesses can look to mitigate against a claim. We're going to then look at managing furlough so that you can manage it in a way that minimises against risk. We're looking at how to protect your business from claims in regards to how you return your employees back to work and provide a safe place of work. So managing the employment relationship can be challenging at any time, but it is even more so now, and sadly COVID-19 is leading to many difficult conversations and decisions having to be taken. You may be thinking, do you make redundancies? Which role is made redundant? Who do you bring back from furlough? Who you don't bring back from furlough? And how do you deal with refusals to attend work? How do you make the workplace COVID secure? And how do you address employee concerns in a way that keeps the business safe? So there is a lot to think about, and you want to do best by your employees, but also keep your business functioning. So having an understanding of what claims there are and how they can come about will help you in your decision making as you navigate through this challenging time. Getting decisions wrong or mishandling situations exposes business to risks from tribunal claims. So I just want to spend a few moments just talking through with you what those claims could be. So first of all, we have an avenue that's the unfair dismissal. So there's a statutory right not to be unfairly dismissed under the Employment Rights Act of 1996. The right is generally subject to several qualifying conditions, such as the employee must have been dismissed, and at the time of the dismissal, they must have 2 years continuous service with the organisation. Now, there are exceptions where that 2-year qualifying service does not apply, and perhaps those that are relevant now in terms of COVID, those dismissals that perhaps are connected to raising of health and safety issues, or where employees are refusing to work in perceived or actual circumstances of danger, or even being or proposing to be an employee representative. They're just some examples of where an employee does not need to have that 2-year qualifying right to bring a claim. We then have constructive dismissal. So this is similar to unfair dismissal in that there is a qualifying service required in order to bring a claim. However, it's the employee that resigns, and it's because of the actions of the employer. And it is this resignation that would be seen as a dismissal, as opposed to the employer carrying out that dismissal. We then have breach of contract claims, and a breach of contract is a non-compliance to legally binding terms as set out in the contract of employment. And we also have discrimination. So under the Equality Act of 2010, this act protects employees who hold a protected characteristic from discrimination in the workplace. So a protected characteristic includes age, sex, disability, sexual orientation, religion and belief, pregnancy and maternity leave, marriage and civil partnership, race, including colour, nationality, ethnic or national origin, and gender reassignment. So the protection covers employees from being directly discriminated against and treated less favourably to someone because of their protected characteristic. Or where there are rules in the workplace or practices that are put in place which then disadvantages a certain group, then that's in direct discrimination. And so it makes it unlawful as well to harass or victimise an employee when that treatment of the employee is connected to one of those protected characteristics that I've just named. We then have an avenue around protected disclosure claims. So employees are protected under the Employment Rights Act who make protected disclosures, which is also known as whistleblowing claims. So they are protected from dismissal, selection for redundancy, or from being made subject to a detriment. So an example here is where somebody raises health and safety concerns but are then later dismissed. That's, they're protected under the protected disclosures under the Employment Rights Act, not to be dismissed for having done so. So as you can see, there's a number of avenues an employee can pursue in order to raise a claim. Now, I thought what would be interesting to see are some top key statistics as provided by the tribunal services. Now, these are for the period April 2018 through to March 2019. And it just to give you some context, now staggeringly, we've got some high numbers here. In particular, if you look at the discrimination claims, your disability discrimination in particular, where an average award, is coming up at £28,000. The next one down is your age discrimination. So with discrimination claims, there are no caps in terms of the awards. So it's really important that as a business we recognise that there are channels an employee can pursue, and actually there is great risk, if they were to be successful, financial as well as reputational damage that tribunal claims can bring. So I thought this slide was quite interesting to just highlight and give some context to what we're talking about today. I think now would be a good opportunity to pause and introduce a poll before we get started and talk about the next section, which is going to be around the redundancy dismissals. So over to you, Sue. Hello, Sue. Hello.
Hello, sorry, is that better? Can you hear?
Yeah.
Sorry. Yeah, sorry for the technical
That's okay.
problems here. So we've got a couple of polls to run here. So our first one is, what do you think your business could be most exposed to risk from? So here are our options. So we've got redundancy dismissals, managing furlough or unfurloughing people, managing the COVID safe return to work, providing a safe place of work, or you're unsure. So we're kind of thinking that you might be exposed to more than one risk, but which one do you think is the most risky? Just collect a few more responses. Okay, I think most of you have voted now. I'm going to close that poll and I'll share the results with you. So we have the most is managing the COVID safe return to work, closely followed by redundancy dismissals.
Yeah,
so,
and
yeah,
that's interesting, probably to be expected, because I think, well, we're seeing a lot in the news, aren't we, about redundancies, and it's probably we're at that point in the whole COVID pandemic where that's, I guess, a consequence of it, isn't it?
yeah.
But also now that lockdown's being eased and more industry is being open, I think there's a lot of nervousness still, isn't there, out there about returning to work and the fear of you know, the transmission of that virus. So I think those statistics, you know, do make sense, I think, to me.
Yes, I'd agree. And the lowest one was actually managing furlough or unfurloughing. So,
okay.
Yeah. Okay, let's move on to the next one. So the next one is, what type of claim do you think your business might be most exposed to? I'm just going to launch that one. So this is bearing in mind what Victoria's just been speaking to you about. So it's whether it's unfair dismissal, constructive dismissal, breach of contract, discrimination, or protected disclosures. Just give a chance for a few more of you to vote. Okay, I think you're mostly there now, so I'll close that poll and I'll share the results with you. So we've got the highest majorities unfair dismissal on 41%.
Okay.
And then we have discrimination and protected disclosures are equal, followed by constructive dismissal and breach of contract is equal. So interesting division there.
Yeah, and I guess the unfair dismissal, I guess, could be in connection with, you know, planned redundancies that we're seeing, and you know, that's one of the obvious avenues for a claim. And obviously the protected disclosures, you know, falls in line with the nervousness about returning to work and providing that safe workplace. So that's really interesting. Thank you, Sue.
Okay, I'll just give that back over to you.
Thank you.
Okay.
Lovely. I shall move on with the webinar. So we're going to spend some time looking at redundancy dismissals and how risk can come about, and what kind of action points that we would recommend you look to implement to help protect the business when you're dealing with the process. We're actually going to do another quick poll to do with redundancy. So Sue, if you could kindly open up this particular redundancy poll, that would be helpful. Thank you. Have we got the poll open?
Sorry. So this is another one of two polls. So we're asking how many of you are either carrying out redundancies at present or plan to do so in the next few months. I think nearly everybody's voted now. Just a few more coming in. Okay, I'll close that poll, share the results. So we've got the biggest majority actually are no, not carrying out redundancies at present. But we've got 25% are currently managing a redundancy process, and 21% are planning to do so but not yet started. So
Okay.
actually, it's probably about 50-50 in the end, of people who are or aren't carrying out redundancies. So if I just hide that one and then ask you a subsequent question, which is quite interesting. So how many of you were actually planning redundancies but have now put this on hold so you can take advantage of the government job retention bonus scheme? This is the 1,000 per person payment if they had been furloughed but were retained as an employee between June 2020 and January 2021. So I'll just launch that one. So we've put a few options on there. Okay, I think most of you have voted now, so I'll close that poll and share the results. So we have, joint first. No, we don't. First is people haven't furloughed, there's 32% haven't furloughed any staff.
Okay.
And then we've got joint second, no, not planning any, and it's not made any difference because they're having to still continue with the redundancy process, or no, weren't contemplating redundancies anyway. So, but 16% are now delaying the decision due to the job retention bonus scheme. So,
okay, that's interesting. And I suppose it all depends on, you know, for that £1,000 that you could be receiving, which I think they're suggesting February, March time, aren't they? Although it's yet to be confirmed. You know, can businesses continue for that long? Is it worth that £1,000? I guess so. I guess there's a bit of financial looking at numbers at the moment, a lot amongst a lot of businesses. But yeah, I think that's a consideration for many. But you know, in theory, it's it's a good bonus that they've obviously introduced. But can people wait that long? So thank you, Sue. So I'm going to continue with the webinar, and we're going to focus on the redundancy dismissals. So when managing a redundancy dismissal, employers will be exposed to claims of unfair dismissal or discrimination. And actually, most employee claims that are successful at tribunal are because of an unfair process carried out by their employer. So I think it's really important to sort of note that, and it's regardless of whether it's a redundancy dismissal or conduct dismissal, it's more often than not the process that lets employers down. So the first important thing to say is that you must be sure to follow a fair and consistent process. But of course, it's probably easier said than done, isn't it, through experiences. So before we look at ways in which you can mitigate action against an unfair dismissal claim in regards to redundancy, I thought it would be helpful to talk through what an employer has to do when defending a claim. So by being aware of this, when you're then managing a dismissal, and it doesn't have to just be a redundancy, it can be any kind of dismissal, conduct, capability, it'll help you in understanding what your obligations are and how to approach the situation. So ultimately, there needs to be that fair dismissal. So a tribunal will expect you to get over 2 hurdles in order to show you've carried out that fair dismissal. Now, the first part is perhaps the easiest, and that is that you've got to show that the reason for dismissal was one of the recognised fair reasons. So this would be either a dismissal for conduct, capability, which could be sickness or performance, redundancy, obviously what we're going to be talking about now, and there's 2 others, statutory restrictions, and that's where if you were to continue employing somebody, then the company would be breaking the law. And there's a 5th and final fair reason, and that's some other substantial reason, which you may know as SOSR, and that is where it could be if an employee, for example, is sent to prison, you've got that legal avenue to actually end that contract, terminate the employment. So I guess that's perhaps your first hurdle. So when you've got redundancy dismissal, your starting point is you've got your business rationale that's driving it, the COVID, the impact of it, etc. And so you're able to put an argument to a tribunal to say, actually, I believe it falls within a redundancy situation because the role no longer exists. So that's, I guess, the easier part. The second hurdle to get over is whether the dismissal was reasonable, and that is perhaps the most difficult to demonstrate, as there's no legal definition to reasonable, which you might know anyway through other ways of managing people through employment. So there's no legal definition of reasonableness, but we do have a lot of case law that helps to illustrate and guide us on that. But each dismissal is going to have its own set of circumstances. What is reasonable for one employer may not be reasonable for another, and it is only for a tribunal ultimately to conclude what is. So I'm going to just spend a little bit more time on the second part, because it's important to have that understanding and awareness. And there are two aspects to the second part. A tribunal will want to be satisfied that A, there was a proper procedure followed, and B, that the decision to dismiss was within the band of reasonable responses. So I'm just going to give you two examples of one that would be a fair and reasonable response and one that wouldn't. So if, for example, you dismissed an employee for fraud, well, clearly that dismissal, conduct dismissal, and a dismissal would be, you know, a reasonable response because of that severity of the situation that's occurred, versus an employee that's got a clean employment record, who then end up being dismissed because they've been late once. Well, clearly this is an extreme example, but it's just to illustrate that that sanction of a dismissal in that scenario is harsh and clearly falls outside that band of a reasonable response. So when trying to establish if a dismissal was fair, a tribunal will be considering whether that proper procedure was followed, and if so, whether the decision to dismiss fell within the band of reasonable responses, and only if it were beyond what a reasonable employer would have done would then a tribunal conclude that a dismissal was unfair. So I know it's quite techy, this slide and this information, but I thought it was worthwhile just illustrating to you the approach that's taken to consider what is a fair or unfair dismissal. Okay, so we're going to just spend some time on some practical steps that you can bring into your redundancy process to help mitigate risk. What I would just add is these practical steps are very much process-based, and what you need to be mindful of is when you're in a redundancy process and when you're in that consultation meeting, if you've got employees putting forward suggestions to avoid dismissals or thinking of different ways you can go about, you know, your approach to responding to a particular event, then you've got obligations to respond and act and manage that. And so your actions in engaging with your employee through consultation will also go towards demonstrating whether that process and that redundancy is fair or not. So obviously for the purpose of today, I can only sort of pretty much go on the procedural side of things, but just be mindful that when you're in those conversations, be aware about what the employee is asking you, putting forward, and consider what your action and response should be to that. So going into any redundancy process, having a good, solid business case is going to be essential because it will feed throughout the whole process, and it can help in defending any case at a tribunal, and it will demonstrate that the redundancy was a reasonable response to the situation that the business was in. It's really important that you follow your own redundancy policy. So as I said, following that procedure is really key for having a fair dismissal. Obviously, if you don't have a redundancy policy, then just give consideration to how you've handled redundancies previously, especially when it comes to pay, redundancy pay. You know, some organisations go above and beyond the statutory redundancy payment, for example, and actually have got a history of paying enhanced redundancy payments. So just be aware of how you've carried out redundancies previously if you don't actually have a particular policy. The role in any redundancy process is the role that is at risk of redundancy and not the person. So there's no, it's very objective and not subjective. There is a legal obligation for employers to send formal written notification of to those who roles are at risk of redundancy. And what we would look to see in that formal communication is your business rationale, the anticipated numbers, the pool that's being drawn, where there obviously has to be a reduction in numbers, the proposed selection criteria, the process you intend to follow, and the timetable that you're setting to manage that redundancy process. There's also the legal obligation to consult. So if you're looking to make more than 100 roles redundant, then you must consult for at least 45 days. And where you're looking to make between 20 and 100 roles redundant, the consultation time frame is 30 days. Where you have less than 20 roles, there is no legal time frame specified in any of the legislation, but what is specified is that it has to be meaningful consultation. So I believe you can do a fair dismissal in a couple of weeks, say. You can manage that process within that kind of timescales. Obviously that's generic and it's all very much depending on the situation and circumstances, but you're not restricted to a particular period of time. What you just need to be able to evidence and show is your consultation period will allow employees to feed into the process, to put forward ideas of how alternative plans might be better, how redundancies can be avoided, so having that opportunity to contribute and put forward counter proposals, if you like. So, and also have the ability to talk about the impact to them personally. So you've got to justify that your consultation period has been in good faith and meaningful. And then there's also the obligation in general for all, regardless of numbers, consider ways in which to avoid it. So ultimately, if you can avoid that redundancy taking place and that dismissal, we should be doing that. Obviously, it can't always be the case, but there is an obligation to consider. We would also suggest seeking volunteers. Redundancy is always very difficult for the business to manage, and also for the employees as well. But you don't know, some people's personal circumstances might lend themselves to actually being an opportunity for that employee to, start having a new opportunity. Financially, it might be welcome to have that redundancy situation and obviously the benefit of redundancy pay. So if you're dealing in a redundancy and actually you've got your volunteers, it makes that process all around that little bit easier, albeit I appreciate it's still difficult. Then there's the piece around suitable alternative and alternative employment. So there is a legal obligation to make sure that employees are made aware of vacancies in the business and are given the opportunity to move to those roles, because that will be seen as a way of avoiding that dismissal. So there is a difference between suitable alternative and just alternative. So a suitable alternative role, what we mean by that is there's another role in the structure in the business and it's of a similar grade, it's of a similar salary level, it has similar levels of responsibility and authorization, and so a kind of a comparable role. It might be in a different area of the business, different department, but if the role effectively is similar in those kind of factors, then it's about talking through with your employees in the consultation process about that suitable alternative, and that's a way of avoiding that dismissal. Alternative employment, is about, there are vacancies that perhaps exist in your organisation. They might obviously not be comparable. It might be significant pay differences. There might be lower levels, but nevertheless, it's for that employee to make that decision whether they actually, at this point in time, rather than face redundancy, they might be prepared and wanting to apply for another role elsewhere in the business. And obviously they'll go through the normal application process to do it, but nevertheless there's you just don't know people's circumstances and feelings towards that. So throughout your consultation period, always revisit your position on what roles you have in the business and clarify what would be suitable and what you believe would not be suitable. And then we have the fair selection process. So that's around where you're looking at reducing your numbers, and that has to be free from discrimination. So some examples of, obvious factors you can look at. So you can include in your selection process, taking account somebody's, the disciplinary record, the performance appraisal record, business knowledge. They're very clear, objective, sound factors that you can fairly use to help select which person is obviously confirmed as redundant and which one, secure their employment based on that selection process. The areas we would stay away from are those discriminatory factors. So for I outlined them a while back around, you've got the protected characteristics of sex, race, religion, pregnancy, maternity, etc., disability. Just make sure your factors don't inadvertently discriminate. So for example, don't use working hours as a factor, because it might be your part-time population may be women because they're most likely to be off for caring responsibilities. So just make sure your process is very fair, free from discrimination, and that will help towards making sure you have a fair dismissal. The important thing, and sometimes this gets forgotten, is that the decision on whether the role is redundant or not actually happens once your consultation period's finished. So everything up to that point, all through your announcement, your consultation, everything is a proposal. This is where we think we're going to have to be. This is what we want to talk to you about. And then you have to conclude that consultation process and then decide and make your and communicate your decisions, because otherwise it brings into question whether you carried out consultation in good faith, and it undermines the whole purpose and aim of consultation. So make sure you close your consultation period, and then it's around reaching your decision and communicating that. And those people that are selected for redundancy, then they are entitled to reasonable time off to seek new employment. So we should be supportive of that and making sure people have the chance to take time out to attend any interviews, any support on CV writing, etc. Throughout the process, make sure you explain clearly how pay is calculated, so there's no ambiguity or confusion at the end. So that's whether it's the redundancy payments, whether it's the notice pay. Some employers process payment in lieu of notice, so it's about being absolutely clear on how payments are managed, on which parts are taxable and which parts aren't, so the employee is absolutely clear, no ambiguity. And then, as with all people processes, formal written records is absolutely key. So follow up on all of your meetings, have that clear paper trail of your process, and especially when you're searching for alternative roles in the business for your employees and looking at vacancies, make sure you've got that written record and that audit trail, because ultimately that will help you in your defence if you're faced with an unfair dismissal claim. And then where you have disgruntled employees and there is a risk of a claim, you incorporate an appeal process. Now, there's no actual legal right to appeal under the legislation, but more often than not, employers will offer them. It's probably more common. They can be useful because ultimately by having that appeal process, what you're doing is you're allowing the organisation to address any issues, concerns internally first. And if you didn't have that extra layer in your process, you're risking people going straight to a tribunal and submitting their ET1 claim. So whilst it's not a legal requirement, it can be helpful where you've got disgruntled employees and you think you're going to be faced with a claim. Of course, work in line with your normal policy and processes. So if your policy does talk about there isn't that appeal process, then yes, automatically offer it, because you don't want to work outside of it. going to move on to managing furlough. Obviously we've got the coronavirus job retention scheme. With the furlough process, you'll probably all be aware that it's entirely new to organisations across the UK. So there's no legislation process that tells us how to furlough or how to unfurlough. So what I want to do is just spend some time giving you the context around the legislation that will back it up and support that particular piece. So furlough must be managed in line with the Employment Rights Act, the Equality Act, as well as the Health and Safety at Work Act, because compliance with these must guide your strategy for how you approach your next steps. And remember, Employment Rights Act protects people from being unfairly or constructively dismissed, and the Equality Act protects people from being discriminated against. And then the Health and Safety Act in regards to providing a safe place of work. And so if the workplace isn't safe, employees are unable to return. So to determine a furlough or unfurloughing strategy up front will help you to ensure you manage your employees fairly, objectively, and in line with your legal obligations. So there are a number of actions you can take to protect the business from claims of either discrimination, treatment, or unfair constructive dismissal. So you should use non-discriminatory criteria to identify who is furloughed or who is brought back if you're bringing back people in different phases. So for example, if you do not need everybody returning at once, a decision to bring only full-time staff back could be indirectly discriminatory on the grounds of sex if your part-time workers tend to be women who are likely to have part-time hours for family reasons. Another example of an unfair approach is perhaps where you select somebody to remain on furlough because they have high sickness absence levels and you fear that having them back would be too disruptive, but their sickness record is linked to a depression. Now, depression, for example, can be a disability in accordance with the Equality Act. So taking that approach presents risk because by leaving them on furlough specifically because of their absence, it's to do with depression, could end up being discriminatory on the grounds of disability. And so there are fair ways, of course, to determine who is furloughed and who is unfurloughed. And again, seeking volunteers is always a good one because, people are putting themselves forward. So they obviously are keen and in acceptance of the situation. I guess with seeking volunteers, the danger is that if people are, remain fearful of returning to work, you may not get people volunteering, and you then end up with having to do some kind of selection process anyway. But also there is a way of bringing them back using a fair process, and that's one that's based on skills and experience, and then grade those employees on those attributes, and the ones with the highest scores are then brought back. You could also look at the health and safety risks as planning who you bring back and managing the approach. So if somebody would be at risk by returning to work because of a very serious medical condition, say for example they're shielding, then you could reasonably allow that person to remain off work on furlough, and your rationale would be for health and safety reasons because it's about protecting their health at work. And I guess the thing I'd also just say is around if you do have disgruntled employees, then by far the best approach is to try and resolve informally first. See if you can address those concerns, because by doing so you may just prevent that formal complaint or even a resignation and therefore threat of a constructive dismissal claim or even a discrimination claim. And as I said a moment ago, record keeping is vital. It's your evidence of your decision making, your actions. So make sure that you're keeping a record of your resource planning, and your thought processes to who you're unfurloughing and who you're keeping on furlough. So thinking back to the poll that we carried out, there's obviously a high percentage of people that are concerned about risks that are associated to people coming back to work and that COVID secure workplace. So we're going to look around the risks that could be relevant here, and some steps that we can take to mitigate that. So again, I just want to give some context around the legislation. So under the Employment Rights Act of 1996, you've got sections 44 and 100, which means employees are protected when acting to protect their own or others' safety. Now, an employee has the right not to be subjected to any detriment or be unfairly dismissed where the employee reasonably believed the danger to be so serious and imminent and chose to leave or refused work. Now, COVID-19 has the potential to be considered as a serious and imminent risk by an employment tribunal during this pandemic. We know that during its peak around back in April time, it was almost certainly going to be deemed as that serious and imminent threat because of the transmission rate and the infection levels. So we think the position could change as infection levels change, but ultimately it is only going to be for a tribunal judge to take a view as to whether the employee's actions to refuse work was in line with their rights under this particular piece of legislation. So I guess I would urge that if you've ever got a scenario where you're dealing with somebody's refusal to attend work, or if they walk out halfway through a shift, seek HR guidance, because we need to understand the context at that point in time and the circumstances. But it's really important to be mindful that COVID-19 has the potential to be considered a serious and imminent risk. And when it is considered a serious and imminent threat or risk, then to bring a successful claim of unfair or constructive dismissal, the employee must show that there were circumstances of danger which they reasonably believed to be serious and imminent. And it won't matter what the employer thought. What will matter is what the employee reasonably believed, and it's that word reasonably again, and it's what they reasonably believed at the time they acted. And so, unlike general dismissal claims, an employee who brings a claim relating to health and safety does not need the usual 2-year service to bring a claim. So dismissals on health and safety grounds are automatically unfair. And remember, a dismissal could occur either through an employee resigning, which is your constructive dismissal claim, or where the employee terminates, or the employer terminates the contract, following a disciplinary process. That's where you get your unfair dismissal claim. We then have another part of the Employment Rights Act, which is section 43, that actually relates to employees who make protected disclosures, also known as whistleblowing, in that they are protected from dismissal, selection for redundancy, or from being made subject to a detriment. And of course, we have the management of health and safety regulations, and the main requirement of this legislation is to carry out a risk assessment, and those businesses who employ 5 or more staff need to record the significant findings of those risk assessments. So naturally, employees will be nervous at returning to work, and we must remember that there will be heightened anxiety around COVID-19, given the psychological impact being significant. So employers may have to deal with some employees who refuse to attend work through fear. And people will have differing views and interpretations on the situation and how it's being managed from a workplace perspective. And so it's really important to manage it carefully and sensitively, and be mindful that getting it wrong, mishandling it, can lead to unfair or constructive dismissal claims. So that's the legal context, if you like, to managing a COVID-safe return. We're going to now look at the actions you can take to avoid and help mitigate against risk from a constructive dismissal claim or whistleblowing claims. And I guess the first thing really that's key, and before any return can take place, is to carry out the risk assessment. This is going to be critical. It's really then important to have your effective communication with your employee early on and engage with them. So through listening and being sympathetic, you need to be able to reassure your employee that their workplace is safe for them to return. Explain your risk assessment, talk through the steps you've put in place. give that reassurance that you're taking the government advice and you're keeping up to date regularly on the situation with COVID. And if an employee refuses to work as they do not feel safe or protected in returning, then remember COVID-19 has the potential to be seen as a serious and imminent risk by the courts for the purpose of the Employment Rights Act. And it's around exploring concerns promptly. So it's going to be key that you're really timely in managing it and talking with your employee. And you've got the opportunity to prevent any further unrest, challenge, and ideally prevent any claim. And hopefully you'll be able to reassure your employee and help secure the return to work. But what you may need to do is explore further measures that could mitigate that fear and the anxiety, and that could be done through your discussions and reviewing the risk assessment. By reviewing the risk assessment, you might identify new measures that just give them that little bit of a reassurance, and all of this will be your evidence to show, if you're ever challenged, about how you've supported that safe return to work. And hopefully by listening to their concerns, you may be able to make further adaptations to the workplace, to their role or to ours, that will help resolve that matter. And then there's a piece around finding the middle ground, because if you believe that the workplace is safe but the employee does not believe it is and is still refusing, then you'll have to show that you're acting reasonably. And again, it's that word, reasonably. So it's about how you approach that, and finding the middle ground is key. So if you can evidence through your risk assessment that you do believe the workplace is safe, you've put measures in place, but they're still refusing, then my thoughts would be a reasonable option then is to allow a reasonable period of leave. Use the disciplinary process, I think, to manage a refusal where other measures are available could be risky at such a challenging time, especially if COVID is to be deemed a serious and imminent risk to people's health. And so the use of agreed leave or even using holiday would be the middle ground if you believe the workplace, as I say, is safe, but they're refusing. Now, whether you pay that leave or not is currently a grey area in terms of employment law, so you may need to make a commercial decision as to whether you pay it or place them on unpaid leave. Unfortunately, we're not going to get a definitive position until it gets tested in the courts, which they're anticipating probably a good 18 months, 2 years away. So you could take a commercial view, decide to treat it as unpaid, knowing that if the courts do not support that position, you'll pay the individual later down the line. But with that, you'll deal with a tribunal application or a settlement process. So effectively, by choosing this commercial option, you're choosing to delay when you may have to pay the individually rather than paying it now. Alternatively, you may feel a better commercial decision would be to pay for the leave or even some of it on the basis that the threat of damage to the company's reputation, if you did not, may be viewed as more harmful for you. So, for example, the impact on employee engagement or any bad publicity that may come from that decision, especially on social media and within the local market at a time when the recruitment market is perhaps going to become competitive for employers. Then for some businesses who may be able to finance this and whom it may only apply to a handful of cases, they may conclude, actually, we'll treat that reasonable period of leave as paid leave. And as I said a moment ago, there's obviously the option of annual leave. But where you've got concerns about people's refusing to work, then, as I said, seek HR guidance, especially around, do we think that there's a real and sustained threat from COVID based on what we know of the pandemic at the time. And then finally, it's around making sure, as with anything, having your written audit trail of all your reasonable steps that you're taking to resolve the concerns and to get them back into work. So I've talked about whistleblowing, protected disclosure cases, and so these next steps are more about trying to develop a culture where you can mitigate risk from getting those claims. And as I said, the rights for employees, if they do make a protected disclosure or whistleblowing claim, they are protected from dismissal, selection for redundancy, or from being made subject to a detriment. So As workplaces reopen, many people are worried about their safety and that of their colleagues, clients and customers, and so it'll be vital to consult, communicate and explain to your staff what measures are in place to keep them safe. But where an employer fails to follow government advice or is putting the employee customers at risk, then that's where there is a claim for a potential whistleblowing claim. And so in terms of whistleblowing, you know, it is a threat, but it's not something to be afraid of. The fear is usually about matters being brought to light outside of the organisation, meaning it's much harder to resolve. If you think about when I said about the appeal process in regards to redundancies, it's far better to deal with things internally and have that extra layer in your processes. So if you can try and find a way in which you can create a culture to encourage that communication, then it's helping you to mitigate those claims. So it's about empowering your employees to speak up, understand what stops people from coming forward, and offer multiple confidential reporting lines. So, you know, obviously there's a grievance process, you've got a HR function perhaps, you've got your policy and you've got other managers. So it's about having different channels in your organisation that employees feel that they can go to raise concerns. Facilitate a trustworthy open door approach so people feel comfortable approaching people, and also give access to anonymous reporting. And with any concerns, then it's always important to act promptly in dealing with employee matters to show that as an employer you do act and you do listen. And what's really important is that you have a clearly communicated grievance policy, that people are aware of it, they know how to locate it and access it. So I think this is going to now move on to a poll because we're coming towards the end of the webinar. So we're going to finish off before a few questions, if we've got time, on a final poll. So Sue, have you got the poll that you can set up?
I have. What we want to do is rerun the one we asked earlier, which was what do you think your business could be most exposed to risk from, to see if there's any move on your thoughts around that. So I've just shared the poll with you. Let's see whether there's been any change in how you vote. Just let a few more vote. Okay, I'll close. Oh, there's a few more just coming in at the last minute. I'll close that now and I'll share the results. So how are we? So we've got the top one is still managing the COVID safe return to work, but there's slightly more people are concerned about that now. So obviously highlighted a few more risks. And the two second ones now in joint second are providing a safe place of work, which is closely followed actually now, and redundancy dismissals. So all the things we've kind of highlighted have moved all the voting in that area. And in fact, there's nobody now worried about managing furlough or unfurlough. I think that that sounds like the easy option.
That's old news now, isn't it, in our world?
So yeah, there's been quite a move between the statistics. Yeah,
and I see that the you know, having gone through talking about the COVID safe return and providing that safe place, you know, it is really difficult and challenging because there's so many different pieces of legislation you've got to be mindful of, and you know, ultimately this COVID-19 is a very serious pandemic, and you know, it's not clear cut. Like I say, you know, at one point, you know, it very much was going to be a serious and imminent risk, but that can change, and it's all very much on the circumstances. But I guess for those people that have put that as their vote, you know, your risk assessment is key. Keep revisiting your risk assessment, keep your dialogue open with your employees, try and resolve any concerns, follow up with people, revisit actions that you've implemented, and just keep that conversation going. And I guess the difficult thing is if you do get people refusing to work, and it's trying to think, okay, think of an outsider looking in, how would they look at your actions you're taking? Would they see my actions being fair or a bit harsh or unreasonable, you know, and sort of just be mindful about, okay, if I'm an outsider looking in, what does it come across as, my actions? So and obviously redundancy dismissals is high up, isn't there, on the 27%, which is understandable given that we're you know, we're seeing a lot take place.
Absolutely. So let me just hide that, and
we've got a few minutes left, I noticed, Sue. So
yeah, just a couple of minutes. We've had a couple of questions through, which I think would be useful to ask at this point.
okay,
And if you have any more afterwards or any further thoughts, then you've got contact details for us. So please do come back and we will respond to you as soon as we can. So the first question is probably unsurprisingly due around holidays and furlough.
okay.
Slightly different to the questions we were asked on a similar webinar about this. This one's saying, can you enforce employees on flexible furlough to take
Okay,
annual leave on the days they don't work, i.e. their furloughed days?
okay. So let me talk this through out loud. So essentially, if we park the whole furlough piece for a moment, an employer does have the right to ask its employees to take holiday around business needs. So all the law requires is that you serve double the notice of the length of leave. So if somebody, you know, if there's 2 days holiday you're wanting somebody to take, you have to give them 4 days notice. That's always been the case and exists. With the furlough situation, what we do know is the emergency legislation that brought in, it gives employees, all employees, whether they're furloughed or not, if they're impacted by COVID, they can accrue their holiday, and they've got 2 years now to take this holiday they perhaps haven't been able to take. So in answer to this question, it's not black and white, and it's actually a very grey area that's being debated by the legal profession. So the conflict is that the emergency legislation says you've got 2 years to take it. The employer has a right anyway ordinarily to ask employees to take it. So I would say you can ask them to take holiday, but do so knowing that if you do, it's not a definitive position. And if you are going to do it, then at least pay them the 100% and not the 80%.
Absolutely.
But it's a grey area and it's yet to be decided. And they're saying that tribunal cases are perhaps going to be taking around 18 months to 2 years to happen, because obviously the backlog, and it's just all been on hold, hasn't it, for months. So there's going to be a period of time where we don't know. But yes, there is a conflict there with the legislations. But if you do, then you might want to make that commercial decision. But if you do make that decision, pay them the 100%.
Yeah. And sort of on the same lines, so for flexible furlough, if you don't have work the following day, I think it is, do they stay on flexible or do you have to furlough them? So I think, yeah.
Well, flexible furlough is for an employer to define whatever hours they need the person to work or not be at work. And I think it comes back to your conversations you're having with your staff members around work needs. So I think, you know, there should at least be weekly conversations. If it's changing that frequently as to how much they work or don't work.
Yeah, I mean, you can vary it. It can be day by day or hour by hour. And I think if your agreement is sufficiently flexible, so you've put them on the flexible arrangement, you will word it in a way that says we may give you 24 hours notice that there's no work the following day or that there is work the following day. So I think it depends on how carefully crafted you have your agreement with them so that you can, it is really flexible, but it can be as flexible as you need it to be.
And the reason exactly.
Sorry.
And the reason is because we want to get the economy going, and the you know, the government recognises businesses need to be really flexible in just adapting and responding. So
I think it's the person who's asking is saying, you know, the agreement is that the work will vary each week, and if 1 week they haven't got any, then I think that's possibly the agreement is slightly too restrictive, so you might want to gain their agreement to for it to be a bit more fluid than that, if that's how you've
Yeah,
found the reality is. But you could
yeah,
re-furlough them at any time.
yeah,
So so you just re-furlough them and then you bring them back to work when you've got work, and then make
yeah,
sure you bring them back again, that it's on a flexible arrangement that enables you to flex it in or out of work as the work becomes available.
yeah.
So I
And it
think you
comes
can get
back to
around
that,
that one.
yeah, and the agreement, see what you've got in your agreement as to how fluid it is, yeah,
To be, or just re-furlough if
yeah,
there's changing circumstances, no work.
okay, yeah,
And the other one was it was regarding the annual leave that we were just talking about. It's because they were on a fixed term contract, so which expires in December, so they wanted them to
okay.
kind of use some up. So I guess
Yeah, so I guess
as long as you pay it in
everything,
full,
yeah,
yeah,
so the situation is still the same. Business needs should be really helping you drive if you need somebody to take holiday or not, but ultimately at the end of employment in any situation, pre-COVID, during COVID, after COVID, you know, when people have got holiday left over at the point of leaving, you pay them for for the unused holiday.
yeah, absolutely. Okay, if we just move on to our last question, which will be, can an employee seek information from a company of how redundancies have been paid historically, i.e. whether it was enhanced or statutory? That's an interesting one. It's kind of
It
why we
is,
say do check what you've done
yeah. So
historically, and so you're consistent, isn't it?
yeah, so I guess if we talk this through, this is around then somebody claiming different treatment, isn't it? Because they're effectively going to be saying, well, you know, previously so and so was paid this and I'm only getting statutory. Well, if you're bringing a claim for discrimination, it has to be for one of those protected characteristics. So you're saying the difference in treatment, i.e. pay, is because of my age, race, sex, nationality, etc., etc. And what I suspect, and probably chip in Sue then, but if it gets as far as that tribunal process, information becomes disclosable. So employers may be asked to disclose historic information. Obviously, there's got to be confidentiality and names redacted, but they're going to have to demonstrate and evidence to that judge what has been paid previously.
Yeah.
Are my
And
thoughts.
I think if even if your policy in the past has been to enhance, if you're in significant financial difficulties and cannot afford to enhance it with this round of redundancies, then as long as you've stated that and as part of your business case, you know, and the fact is you would potentially have to make more redundancies if you enhanced a few. If you know, you either enhance a few or you make more. Sorry, you either make more redundancies or less redundancies and enhance.
Yeah,
So it depends on how it's viewed and what you want to achieve and what you can afford. So
yeah,
you just need to be aware of what your previous policies were and be aware of being consistent and why
yeah.
you would change from that.
And perhaps, like you say, the tribunal will, you know, surely they've got to consider the impact of this COVID-19. You know, the significant. It's not like any other normal
No,
situation, is it? And so the strain on businesses to just keep running and surviving. I think surely that
it's
must be
huge. Yeah.
a reasonable thing to consider if you're an employer as to actually probably what you pay. But
Yeah.
consistency is important. But yeah, good point there, Sue.
Yeah. Okay, thank you. Thank you very much, Victoria. We will close the questioning now, but as I said, if
Okay.
you have any further ones, please do come back to us. Just to continue with the slides, I did take control while you were answering a question.
Okay.
So just to let you know, we do have a return to work service. So if you do want to sound out your plans or discuss your plans further for getting people back into work, then do let us know and we can give you information about what options we have available to you. We have various audits available. And also planning strategies that you can use to look at resources and things you need to do in the workplace. I've already talked about the further questions. As always, we would very much welcome any feedback on topics you would like us to talk about in these webinars as well. If we haven't covered anything you would really like us to cover, then please do contact us and let us know. Just to let you know as well, we are running a few more webinars and we're adding to them all the while. So we've got a couple on diversity coming up this month, and then we have one on the future of work, so that's looking at flexible employment practices in August, and conflict resolution in September, which is looking at managing grievances and mediation. So, but we are looking at 1 or 2 more that we'll be adding in as we go along as well. So keep your eye on the website and sign up for our newsletters, and you will be informed as they come along. And there's the sign up information for our newsletter. Copies of these slides will be mailed out to you. You'll get a link to download them if you wish, and as well as a copy of the recording of the webinar. So thank you all very much for attending today. We are hopefully we will see you virtually on a future webinar, and all of you stay safe. Thank you.
Thank you, everybody.